Well, good evening. I am Tigress Sydney Acute McDaniel, and we are now live for the video, the explainer video that I have committed to providing to you all, Greater Charlotte and beyond Charlotte, America, so that this matter can be resolved with finality and most justly so in my favor. All right. So this is all about the truth regarding the fraudulent gatekeeper order. So give me 1 second. I want to make sure that I am where I need to be. I can take your comments. I can take your comments. Okay, yep, I can see it, I can hear it, let's see here. Yep, and it is streaming on my other channels. Let me delete the other so that no one is confused. Don't go over to YouTube because I have deleted that one. So I'm deleting that from my feed now so that it doesn't confuse anyone. You are in the right place, all right? Let me get over here. I want to make sure. Okay, I've got my chat here. And I'm going to move this over so I can see this. Right now, I'm just doing a little housekeeping so that I can actually see your comments in real time, if you have any at all. And then I can also see my screen, my live feed, so that I can answer, so that I can actually see that the documents that I'm presenting, you can see clearly, okay? So let me get this together and then we can begin. I do hope all of you are well tonight. I am well. Yep, there we go. All righty. So I can see your comments. I'll be able to see that you can see the documents that I am presenting, and we can move forward in that regard. I am going to stick to the facts. I am not going to make any supposition. I am not going to make any inferences, because no such thing is necessary. There is a Latin term in law, res ispa loquitur, which means the thing speaks for itself. And that's what's going on here. All right. So what I'll do, I will start off by reading the description that I gave to you all so that you have an overview. I'm not sure how many of you have read it, but I'm going to read it again for you. So this live session is an interactive explainer video which reveals the facts regarding the ill-gotten gatekeeper order fraudulently effectuated by Emily Jeffords Meister, Judge Carl Fox, and Judge Webb in Guilford County in 2013. Also, the copycat gatekeeper order fraudulently effectuated by Richard Huffman and Michelle Feinstein, that's a misspelling, I'll correct that, Bailey, and Judge Anna Mills Wagoner to evade the valid 2006 money judgment against Bailey in my favor, and the renewal of that judgment 10 years later in 2016, and also, most commonly known, the 2018 copycat gatekeeper order here in Mecklenburg County, fraudulently effectuated by attorneys Melissa Jamie Woods, former CMS counsel, F. Lane Williamson. Some of you will remember this name. He was the attorney for the volunteers that was, the story was twisted. It was intentionally, fraudulently misrepresented by the Charlotte Observer and F. Lane Williamson as me going after these poor volunteers who had done nothing wrong to my son. Also, of course, the judge, the presiding judge who actually entered the order was Judge Lisa Bell. And this was all to evade my valid complaint for violations of my son's 504 plan committed by CMS teacher Patricia Falk, who gave my son a food product containing milk, which resulted in a severe allergic reaction and remedial surgeries under the care of Levine's Children's Hospital, where he's seen, and otherwise to effectuate a smear campaign to discredit my efficacy when I was running for office during that time. This is to proactively address any who would intentionally obfuscate white women tears as somehow on par with a racial slur. This term is legitimate research jargon. I assuredly didn't coin the term, and studies in real life demonstrate its validity. So during the pandemic, white woman tears, that jargon became especially widely known. There was increased awareness around it. Again, it is already part of the jargon for psychological research as it relates to racial discrimination, especially covert discrimination, the gentleness and the softness of the white woman juxtapose the tropes that have been assigned to black women, especially like myself. I'm 5'9", I weigh 180 pounds. So juxtapose that, like I would have to necessarily be hard and savage and not soft and delicate like the white woman. And of course, keep this in mind, not all white women subscribe to racism. Not all white women. So this is not an attack on white women in general. This is a statement of the facts and how Emily Jeffords Meister, a Caucasian or white woman, used her white woman tears against me, fraudulently so, to effectuate this ill-gotten gatekeeper order in 2013 that has been copycatted in fraudulent conspiracy. So in fraud and conspiracy, because I guess that's like it's redundant, the conspiracy to commit some act. And then in another regard, it's not necessarily redundant because you have the conspiracy that can be any type of act. And in this particular case, it was fraud. It was a convenient legal tool for them to abuse to effectually win cases against me that they would not have won had they not effectuated the gatekeeper order and then enforced it in bad faith. And that will all make more sense as I continue to expound upon this. So we must begin with the 2013 gatekeeper order. So give me 1 second here. And I don't see any comments, so it's kind of wild because I can only see, so much. All right. Okay. And actually, before starting with the gatekeeper order, we have to start with, why did I interact with an Emily Jeffords Meister? And why did an Emily Jeffords Meister interact with me? What is the case from which their interaction, mine and, I'm speaking third person, my experience with her and her experience with me, where does that begin? In 2013, when I was running for City Council District 1 in Greensboro, North Carolina, in Guilford County. I visited the restaurant, Ham's Restaurant, downtown Greensboro, with a friend, Alexandria. Her name does appear, her full name appears in the record. There's no need to further subject her to harassment, considering everything that is going on. Let's see here. So, but again, her name does appear in the record. All right, so let me pull these up. Okay. Okay. Let me tell you. Oh, reliving this, y'all. Reliving this. Okay, so basically, when we were at this restaurant, we experienced racial discrimination. Alexandra is also a Caucasian or white woman. So again, the notion that my statement that Emily was motivated by white woman tears and using that, weaponizing her tears against me, is not somehow wholly racist, because of course we know that I'm not a racist. We know that. Okay. In this case, so basically at this restaurant we were discriminated against, and I did move for a complaint because the racial discrimination that we experienced was pretty severe. And Alexandria and I discussed it, and she agreed to provide witness, and so I proceeded upon that. Okay? Emily Jeffords Meister, I later learned, because she's the counsel for Ham's Restaurant. She appears on record, and that's how it goes. You have an attorney who appears on record, and she appeared on record on behalf of Ham's Restaurant. So then you have what are called preliminary hearings, right? So we had preliminary hearings on this or in this matter. While attending, or while appearing in that case, myself and Alexandria, we were there, together at the Guilford County Courthouse. During this hearing, Emily was making very inappropriate remarks to myself and Alexandria. The commentary from the bench, the presiding judge, she directed us to speak about the, just preliminary hearing matters, just, before trial matters. And that's normal, because if you are handling discovery and subpoenas and things of that nature, then the judge will direct you to confer with the opposing counsel. So that's all normal. However, the judge was not, she was not hearing the things that Emily Meister was saying, and her demeanor towards us was completely inappropriate. So as we were walking out, as we were dismissed from that particular hearing, Alexandria and I, we intended to exit. We were on the second floor of the Guilford County Courthouse, and we proceeded to the elevator. We get to the elevator, and we noticed that Emily Jeffords, and I'm just going to refer to her as Emily at this point. So Emily is rushing toward us, and she begins threatening myself and Alexandria. Because she puts her hand in between the elevator, and I had already told her I did not want to, have any conversation with her as we were leaving out because of her demeanor. Well, that was not good enough. And this is the common behavior from those who are in the white community who do have racist, belief systems and are prejudicial toward, black women. And so she was very, very, extremely rude, very threatening. She said that she would make sure to destroy me. And immediately I said, I'm going to get the deputies because I'm not going to deal with this. And that's immediately what I did. I yelled out for the first uniformed person that I could observe. And that happened to be Detective Steve Flowers with Langford Protective Services, Inc. So, let's see here. And he took a report at my request because I was completely concerned that she would act upon her threats. And I had learned during this hearing and prior to that Ham's Restaurant was owned by some pretty questionable individuals who were widely known for being associated with organized crime. And so I was very concerned for my safety. I was concerned for Alexandria's safety. And again, Alexandria was in complete agreement with me in seeking the intercession of the uniformed officer that was in the courthouse. And so this was not something that was just happening with just me. There are witnesses. The detective responded. It's widely, it's widely verifiable, if you will, or easily verifiable. So this case number, let me see. I'm gonna hold it up. I'm pausing for a second because I want to make sure that you can see it. Let me come over. Okay, there we go. The case number is 13 CVD 8328. And you'll notice I'm going to show you a series of subpoenas. And of course, I'm going to make sure that this is readily available to you. You can also stop, pause, record, any of those things. Because at the end of the day, as you can imagine, this is very hard and burdensome and stressful for me to have to relive this, especially when you understand at the end to the extent that this gatekeeper order and her white woman tears have been weaponized against me. Here's the other subpoena. So basically, and I mentioned Detective Steve Flowers. So let me go ahead and put that up. These are subpoenas in the complaint for a TRO that I filed against Emily Meister after Steve Flowers Detective Steve Flowers assisted in taking the report and together with Langford Protective Services, Inc. Okay, so that's Detective Steve Flowers, as you see there. And so for obvious reasons, in this action, I subpoenaed the Langford Protective Services, the detective, let me see these, okay, make sure you see all that, all right, the detective, and I also subpoenaed the surveillance video for the courthouse, because of course there's surveillance video. Okay. Yeah, Guilford, this, as you saw, that one actually says Guilford County Security, right? Okay. And this was a big ordeal, you guys. It was a big commotion. She was yelling. In fact, as the security officers came to intercede on our behalf, she continued to yell. She continued to threaten us verbally. She even threatened the officers there as they were walking us away and giving us a courtesy escort to exit the building. She was still following us all the way from one floor to the next floor, because we ultimately got off the elevator and walked down the steps. I don't know how familiar you all about the Guilford County Courthouse, but it was, at least there are two, it's kind of like you make one flight of steps and then you come around and you make another flight of steps. So this whole process, and then going around a little ways to get out of the building, she continued to follow us, and she was not backing down. It was ridiculous. Her behavior was despicable as a licensed attorney, and she knows that. She knows that. So, again, the TRO complaint was appropriate. How in which and ever. All right. Let's see here. During this TRO hearing, and let me show you that so that you see this. All right, so here is the complaint, and this is filed September 26, 2013, okay? All right. You see that there? And you can see very clearly that I am the plaintiff and Emily Meister is the defendant. Got it? And listen to me. Judge Susan Birch was the presiding judge. You see that there. Okay. Judge Birch would not allow the witnesses to testify. She wouldn't allow Langford Security Services to testify. She wouldn't allow Detective Steve Flowers to testify. She would not allow the surveillance. She basically deaded my entire case without proper cause. Okay? Hold on 1 second. All right, hold on. Let me pull out some more here. And so, as you saw, Judge Susan Birch then unjustly, unethically decided that I had failed to prove that a TRO was appropriate. Okay? Well, this further fueled Emily's rage against me. And effectually, this becomes a hate crime because she was motivated by racism. You understand this, okay? All right. Let me go further here. So at this point, then, what do you think happens? With her rage fueled, and with the judge siding with her, she was then, and actually let me show you also, because this part of the complaint actually shows the issue with it, this actually shows me detailing what occurred. So on September 17th, I'll show this first. Okay. There was a simple assault against me with a witness present. She advanced toward me in a physically threatening manner and exclaimed, "Go to the news and it will be a problem for you, and I'll get you and I will destroy you." While making an extremely threatening hand gesture after pointing her finger at me. I have substantial reason to believe that she will basically act on her threat and enlist others to assist her. Okay? Herein lies the sheer irony. Everything I said was accurate, and everything she did that I have recently discovered demonstrates that my allegations in my complaint for a TRO were demonstrably factual as alleged. Because that's exactly what she did. She did exactly what she said she would do. Okay? All right. So the next thing I get is a motion for a gatekeeper order and a defamation lawsuit from her. Okay? Oh boy. Okay. Meanwhile, so basically at this point, Judge Webb is the presiding judge for that hearing on the gatekeeper order. And the gatekeeper order is entered against me. And that date, I'll have to add that document to this feed. Make sure here. But yeah, so it's referred to this. And it was a preliminary gatekeeper order sought and actually I can add it now. Sought and obtained by Meister and was filed on October 8th, 2013. So remember, we have the 17th is the date of the incident, September 17th, 2013. September 26th is the date in the hearing on my complaint for a TRO. She then moves for a gatekeeper order, which is completely unsubstantiated, improper, unlawfully retaliatory. But she proceeds upon it, and she is successful in getting Judge Webb, Superior Court, to enter this preliminary gatekeeper order against me on August 8, 2013. Okay? Okay. So during this time, now keep this in mind, this gatekeeper order that Judge Webb entered, it applied to all of my actions in the Guilford County jurisdiction. And I believe that I had maybe 2 other cases that I was handling, and I will refer to them in Judge Patricia Hennett's order here in a minute, which is highly material in this regard because Judge Patricia Hennett actually significantly modified the gatekeeper order, and the reasons for doing so are material. Understand? Okay? And when I say material, I mean important. Okay? They are very relevant to the nature of Emily's conduct. Okay? All right. So we have the October 8th, 2013 preliminary gatekeeper order. And I immediately filed a motion to vacate that gatekeeper order because it was completely improper. In attempting to, litigate that, and the bad faith enforcement of the gatekeeper order. So what does that mean, Tigress? What is bad faith enforcement? So this is a great time to step over to the North Carolina Superior Court Judges Bench Book, which details just cause for a gatekeeper order. And hold on, for whatever reason, I'm trying to make sure. I thought I had all this, and I apologize, but give me 1 second. No worries. I was prepared, as you all know me to be. So, because I, for whatever reason, only have page 3 and page 4 of this North Carolina Superior Court Judges Bench Book in my binder. But it can be easily accessible or easily accessed online. Hold on 1 second. And so I'm going to pull that up. It's the first thing that comes up. Okay. Here we are. And so this is what we're looking at. So I'll show you in real time so that you see I'm not making it up. I'm going to pull it as close to the screen as possible so that you can see it and make sure. And you'll see in real time the bench book from UNC EDU. Got it there? All right, and this is live. It's not a PDF, so you can find it very easily. As you see, you can scroll and go straight to it. All I did was input the following keywords to pull it up. NC Bench Book pre-filing. See that there? And then you can select the first link and it goes straight to it. Easily accessible. So the reason why we're going to this is because this sets the standard for gatekeeper orders. This is the governing case law, if you will, or applicable. Well, it is governing and applicable case law for gatekeeper orders. Number one, they are rare. That's number one. I'm going to take full liberty to read through each of the requirements, the elements that constitute an actionable gatekeeper order or that justify a gatekeeper order, okay? So basics of gatekeeper orders. A, court's authority. Courts have inherent authority to enter pre-filing injunctions, also referred to as gatekeeper orders, restricting individuals from filing new lawsuits or other papers without court approval when necessary to prevent abuse of the judicial process and protect other parties. B, last resort. The gatekeeper order should be a last resort after other attempts to control the litigant, such as Rule 11 sanctions, have failed. C, notice to subject of order. As with any disciplinary matter, because the gatekeeper order, like contempt of court, has a punitive element to it. And thus, hearing rights, which are germane, or they are inherent to one's constitutional rights, must be regarded. That means that a person who is subject to contempt must have an opportunity to be heard in defense against it, similarly to a gatekeeper order. Okay? So notice to subject of order. As with any disciplinary matter, the subject must be given notice of the proposed order and a chance to respond before it is entered. D, it must be narrowly tailored. The order needs to be narrowly tailored to the circumstances showing abuse. That is, if all the abuse of litigation is directed at one particular party, the order should only limit filings related to that party. Or if the frivolous filings are all in one county, the order should be limited to that county. E, specific history. The order needs to specify the history that has led to its entry in sufficient detail that an appellate court can review for the trial court's abuse of discretion. F, include means for filing legitimate actions. The order must include a means for the person to file legitimate actions. One possibility is to require that the proposed filing be first submitted to a designated judge to be approved for filing. Another option is to allow a filing if it is accompanied by a certificate from a lawyer that the lawyer has read the document and has also read the gatekeeper order and concludes that the filing meets the standards of Rule 11. A lawyer's certification should not be the only alternative available, however, because that would have the effect of requiring the person to employ a lawyer, right? And of course, they know that I was indigent, which means that I was given a waiver of the cost of court because I could not afford them. Waivers can be approved on the basis of not being able to afford something, and it doesn't necessarily mean that I was on welfare or dead broke. I was a college student in my master's program, going into my PhD program, and I could not reasonably afford the cost of court. Okay. G, instructions for the clerk's office. Either in the gatekeeper order or separately, the court should instruct the clerk's office on how to handle improperly filed documents. The clerk might be instructed to not accept for filing any papers from the litigant without a signed approval from a judge, for example. H, notice to other parties. Notice of the gatekeeper order should be given to all parties who have been on the other side of cases from the abusive litigant. So, hold on. All right. So they will know of relief available to them if frivolous documents get filed despite the order. I, opportunity for modification. The order should include an opportunity for modification. For example, the order might allow the affected party to seek a change after 6 months or 1 year, or the order might provide for automatic review by the court after a certain time. Okay? And then it goes on, it shows different cases that are applicable. So that would be case law. And so you can, look over that. Okay. So here we are. Judge Webb has entered this preliminary gatekeeper order. Was I properly noticed? No. So that violates the bench book. This gatekeeper order, was it the last resort? No. It was entered upon the first request of Emily, motivated by racism and further fueled by the unjust conduct of Judge Susan Birch in disallowing the clear evidence to be presented that would show that Emily Meister had behaved unlawfully in physically assaulting me. And understand that physical assault does not necessarily mean that the person has to be touched, quote unquote. There are hold on one second. My son I believe he wants, I baked some macaroni and cheese, and hold on one second. And he wants that. This should be very interesting. Hold on one second. And actually, this is a great example. I'm glad, because this, even though this is admittedly somewhat annoying, because he knows that I am downstairs in the office, in our co-work area, and he knows that I am making this explainer video. Okay. This further proves my point. I'm a single parent. And I'm a single parent 24/7. I'm the custodial parent. Hold on one second. Stop. And he requires parenting. He's a new teenager. He is not completely self-reliant. And at the time when this gatekeeper order was entered, he was 3. And during all times material thereto, he has been a minor who requires attention and parenting, okay? So in addition to my PhD program, because my Juris Doctorate program did not begin until 2019. But in addition to my PhD program and me running my business and being a single parent and recovering from a car accident I had, some of you are familiar with it, some of you are not. And this is relevant because I had a case against Dr. Vincent Paul. And this was during this time. And I had been in a car accident from which I sustained an ankle injury. And I sought his services, I sought his care. He's a chiropractor. And I'm sorry, not a chiropractor. He is an orthopedic doctor. And I refused the cortisone shots. And on one particular visit during the examination, he gave me a cortisone shot against my will, and it caused me further damage. In fact, it caused nerve damage. And I used to have spasms that would shoot up my right leg for this. I was seen by another doctor after discontinuing my care with Dr. Paul for obvious reasons. Dr. McKinney in that same office agreed to be a witness in the malpractice suit that I had against him. And later, another orthopedic practice, they confirmed that the cortisone shot, the improper injection or the improper administration thereof, caused the nerve damage to my right ankle. And I was diagnosed with complex regional pain syndrome, okay? Some of you know this if you lived in Guilford County and you saw me in a boot and all the things, you know these things, okay? All right, so this notion that, again, we're gonna kind of reiterate it here or there as we speak about everything that transpired. During this time, a lot was going on. In my life, in my personal life, as I just explained, in my academic life. And so the notion that I somehow filed 162 cases in 72 counties is absolutely absurd. And mind you that I was, at that point, I was definitely a broke PhD student. And also during this time, because I had lost my business that I started while being on while receiving my unemployment, I opened a shop downtown at 316 South Elm Street called Passion Live. It was the first ever for-profit arts cooperative. Charles Miller was the owner, and I leased the property from him. And that was a complete nightmare. So those are the two cases that I'm telling you that I had at the time. So one against Dr. Paul, and then one, it would have been 3 separate actions. 2 of them were related to the same car accident. So one was against Dr. Paul for medical malpractice. One was against Johnson and Antoinette Samad, I believe it is. And that was the individuals who had hit me. So it was a hit and run. The police officers later found them, and they were held accountable, of course. And so I had the lawsuit against them for personal injury, and I won that. I got a judgment for $15,000, okay? All of these are in the Guilford County record. All you have to do is search my name, Tigress Sydney Acute McDaniel, in the civil records. You don't even have to go up to the clerk's window. They have a civil record search, and you can enter my name. You don't even have to enter my full name. You can enter McDaniel, Tigress, and you will see everything that I'm talking about. It's right there, all during the same time frame. Okay. All right. And we're gonna learn where this 162 cases in 72 counties came from. Just know that started with Richard Huffman, and you'll see why. Okay, that was the second gatekeeper order, the copycat, because it's been copycatted, if you will. All right, so now we understand that we have the September 17th was the date of the incident where Emily assaulted us. And actually, let me pull that up so that you have, because some people are going to say, well, did she touch you? Da, 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 da. The elements for assault, the definition of assault, we're going to pull that up. Okay. All right, so in North Carolina, it falls under the criminal law code, of course, chapter 14, and it is not specifically defined by statute, and therefore relies on the traditional common law crime of assault for definition, okay? Let's see. In North Carolina, you can be charged with assault even if you do not touch them. So if you advance towards a person with the intent to harm, that is assault. Okay, so let's make sure we have that clear. So I don't want anyone thinking that I am exaggerating the occurrence. I am not. Okay. All right, so now that we have that understood, we know September 17th, we know September 26th is when I proceeded upon my complaint for a TRO. We know that was denied by Susan Birch. We know that then further fueled Emily to weaponize her white women tears against me, and the favor of the court, upon her, unlawfully so, unjustly so, but that then motivated her to seek a gatekeeper order against me, where such was completely inappropriate. There had been no history of abusive filing. In fact, it was quite the opposite. I've always had great rapport with the Guilford County Courthouse. And I have not filed anywhere near 162 cases. I have filed, and I believe I reported on this about 2 years ago, at that juncture, I had filed about 35 cases in my lifetime, okay, in my adulthood. And those were cases, remember, I am self-employed, so those were related to slow pay customers where I would file my complaint in small claims for indebtedness that a client owed me, on some invoice, or, just simple matters. Nothing that would even remotely constitute abuse of litigation, nor abuse of the judicial system. And I won at that juncture 100% of my cases, okay? All right, because I don't bring forward frivolous cases. All right, so basically, Judge Webb, motivated by Emily's white woman tears, enters the gatekeeper order. Albeit preliminary, he still enters it, and it is a sweeping restriction for all of my cases, which makes it completely inappropriate because it is not narrowly tailored, number one, maybe narrowly tailored in the sense that it was, tailored to the county, but it was not consistent. It was not compliant with the bench book in that, let's see here, it should have been, number one, the last resort after other attempts to control the litigant, such as Rule 11 sanctions have failed. He did not start there. The order I was not given proper notice. I was not properly heard in defense. There was no opportunity for modification that was written into the order either. Okay? So this was completely non-compliant with the bench book. And it looks like we are going to go to 8:30 and then I'm going to stop, because I'll be able to clarify everything else. Once we get past this part, because this part is just so much, everything else you've either heard me refer to in my video, my explainer video regarding the wrongful conviction in 2006, because I referred to the bail bondsman and the destruction of my vehicle that I had used as security for that bond in that particular criminal case. And Michelle Feinstein Bailey was the bail bondsman in that case, and Richard Huffman was her counsel. So you've heard me refer to that. So that may not be new information to some of you, and those matters kind of go a bit quicker, but I didn't realize what Emily Meister had done behind the scenes that then provided this convenient padding opportunity. And I mean, like, you know how when you pad a case with fraudulent information? Well, that's what Richard Huffman had done. Okay, and some of you are figuring this out already. You may have been at the event the other day with the Dems, Democratic Party, at the church downtown, where Drew, the chair, he acted completely unlawfully and unethically in the accusatory manner that he presented the question to me about the gatekeeper order, especially being a licensed attorney and having actually also touted, well, I am a licensed attorney, so I know exactly, his implication was that I know exactly how 162 cases in 72 counties can be filed. Well then, honey, tell me, because I'm not really sure how to do that. In that time frame and with the resources that I had, I don't know how to do that, honey. At all. And neither does he, unless you effectuate fraud, okay? All right. So let's get back to the point, because we're going to make sure that we are remaining objective and we're sticking to the facts. All right. So here we are at the Gatekeeper order in 2013 with Judge Webb. I then moved to vacate this Gatekeeper order for obvious reasons. I had to assert myself like the Dickens, and I'm using assert very loosely because it was like hell. Because basically at this point, Judge Webb's 2013, this initial preliminary Gatekeeper order, because it was a sweeping restriction, and because they were, and I think we got, I was speaking about bad faith enforcement. The bad faith enforcement is what makes the Gatekeeper even more so constitutionally violative. So let me explain. What does bad faith enforcement mean, Tigress? So basically, are you going to enforce this in such a way that is directly consistent with law, so as not to subject me to unfair punishment? So if you're saying that this is fair punishment, the Gatekeeper order is fair, if this is what they're saying, right? They still yet have to regard my constitutional rights of due process. So that means that you can't put a Gatekeeper order on someone to win a case against them. That's bad faith. You can't put a Gatekeeper order against them, and then when they file so basically it would say, hey, you need to submit whatever you want to file upon the court to us first, and we're going to approve it. Because remember, I couldn't afford an attorney. So my only other option was to then submit my pleadings directly to the judge's chambers for their review and approval, right? Oh, honey, that is not what occurred. I made many attempts to submit my pleadings. They were rejected by staff members in the judge's chambers. I had to reassert myself, and then finally they were accepted by those in the judge's chambers or the staff for the judge's chambers. They would not review them in a timely manner. 30 days would elapse, 60 days would elapse. They would not respond altogether. They would return my pleadings without providing me a administrative order giving me approval to file my pleadings. Because remember, if I go to the clerk's office, if you say, hey, we reviewed it, if this judge is saying, hey, we reviewed your pleading and we're giving it back to you to go file. Well, no, that's not going to work, because when I get down to the clerk's office, you've already told the clerk's office that I'm evil. Well, let me refrain, because that's not an objective statement. You've told the clerk's office that I am restricted from filing, but you have not given the clerk any order that shows that you have approved the filing of my document. So then I go down to the clerk's office with your verbal approval, and that presents conflict because the clerk is not going to accept it. And this is why it's written into the bench book order, that the bench book standards, that there should be clear directions given to the clerk's office. But that wasn't the case for me. And even when asking for an administrative order for approval or even denial of my pleadings that I had submitted for review, the judge's chambers Judge Webb refused to give that to me. I had to reassert myself several times before they began to even concede to providing me that order. I finally got the opportunity to get before Judge Hennett. Judge Hennett then heard my motion to vacate the gatekeeper order. And this was, hold on, let's get to it. Yeah, all right. This was, keep in mind the time frame. So we said that it was entered October 8th, 2013. So the bad faith enforcement of the gatekeeper order lasted until June 2014. And this is when Judge Hennett significantly amended the gatekeeper order. All right, so we had our hearing on March 3rd. And it took a while for her to even enter the order. Let's see what the date on the end of it says. Yeah, it was heard on March 3rd, and then she still didn't enter the amended gatekeeper order until June 6th. You'll see that there. So during this time, keep in mind that my pleadings they are basically being rejected, or the better word is ignored, because there wasn't a formal, we're denying this because you're submitting something that's improper. There was no history of me submitting any document that was improper, right? It was just, we are ignoring your pleadings. Now, keep in mind, I have these other cases that are pending before the court, and I am required to answer the opposing counsel's pleadings. I'm also in the position where I appealed the denied TRO. You know, what Susan Birch denied, I then appealed that. And that would go to the higher court, right? That at that time, and you have to understand that the law has changed, so that would not have gone to the Court of Appeals initially. And so Emily Meister was able to effectuate an ill-gotten dismissal of my appeal on the basis that I had failed to prosecute because my pleadings were not being reviewed in a good faith enforcement manner. They were intentionally acting in bad faith to subserve, which means to gain an unfair advantage over me in all of my cases. So basically, this is the first time ever in my litigative history where I started to lose cases. And I only lost the cases because of the bad faith enforcement of the gatekeeper order. Because it was being weaponized against me to destroy all of my valid cases and dispose of. Now again, so based on my complaint for TRO, I said that I bring to the court's attention that Emily will act out her threats and enlist others to assist her in such undertaking. So that means that my allegations were demonstrably factual as alleged. It gets worse. So basically during this hearing, and it's very important that you, and what I'll do is I'll make sure that these are available on my website as well, and I'll figure out the most convenient way to put them here as well. I use Scribd, and it allows you to be able to see the documents. But yeah, so let me give you the gist here. So this amended gatekeeper order, I feel like, and I'm going to read through it. It's not going to take long. It seems like it might, but it's not. It is 10 pages long. And the reason why I'm going to do that is because I don't want anyone to get the impression that it's that I'm being one-sided here. Number one, we're going to point out the most obvious, the most egregious issue in this document. So many of you know that I changed my name, my legal name, in 2004. This is 2014, 10 years later. And you'll notice that it has formerly known as Tasha Renee McDougal. Why would that be necessary? That is my defunct name. I don't use that name. I had not used that name since changing it legally in 2004. But this is how Emily drafted and captioned her complaint. The intent was to fuel the court's disdain against me as having somehow an alias to which a criminal matter could be assigned. The irony is that, you guys, I was incarcerated under the name of Tigress Sydney Acute McDaniel. I don't know why you all think that I was incarcerated under Tasha Renee McDougal. That's not the case. The Cabarrus County criminal action has both my birth name and my legal name. So there's no way that I would be able to get out of it as what some have maliciously sought to have people believe. There's no truth in it. So this was her intention. This was complete intention. It was completely improper because at this point, the legal effect of changing your name means that Tasha Renee McDougal doesn't exist anymore. And even where I acknowledge my birth name, I don't deny it at all because I don't have anything to hide. I can't use it, so I don't use it because it's not proper to do. It's not ethical and it's not lawful. So that was the number one issue that you see. It's facial. Her motive is demonstrated by how she captioned her complaint against me. Okay? So we'll go to it, and we're gonna and these things are very, very interesting. Okay, these are material facts that you need to know. Okay, so on March 3rd, 2014, Meister presented a request for a permanent gatekeeper order. So she not only got the temporary, now she wants the permanent gatekeeper order. Okay. And then she wanted default judgment and damages. The request by Meister for a permanent order was countered by a request from McDaniel to lift the order since the only involvement with plaintiff was related to the underlying action. The request for a gatekeeper order was filed simultaneously with the complaint on September 23rd. And I guess it is going to have to take 2 hours, y'all. I'm sorry. I've done my best. It's just so much. And this is not my traditional manner in preparing an explainer video because I would normally prepare it and then organize it very concisely and edit it so that it's, this well composed video production. I don't have the energy for it because it's so much. It's so stressful. Even aside from the recent death that I experienced, it's so stressful. All right, so the request for a gatekeeper order was filed simultaneously with the complaint on September 23rd, 2013. She's referring to Emily. The hearing date for the preliminary gatekeeper order was set for October 7th. McDaniel was served in person on September 25th by a deputy sheriff, dropping the documents at her feet. Do you hear this? Defendant was not present at the hearing for the preliminary gatekeeper order on October 7, 2013. I was not served. I did not receive service. Just understand that. And I find that statement very, very interesting. There's no documentation, no proof of that the sheriff dropped it at my feet. I believe that Judge Patricia Hennett referred to that on the basis of what Emily had certified to the court as a licensed attorney. But that didn't occur. Remember, I did not receive notice. The preliminary gatekeeper order was filed on October 8th. And let me make sure you understand this as well. Generally, when there is a punitive implication to any type of show cause hearing, motion for contempt, motion for gatekeeper order, motion for sanctions, and the party does not appear, even if the attorney who's seeking these punitive action, right, has shown that they have properly served the party that is subject to this punitive action, it is most proper for a judge, and I've seen it. I've been a part of the audience. I've seen it. I know it to be proper conduct by a judge. The judge then continues the case and normally orders a bench warrant or something to that effect, show cause, a direct, further directive to appear, right? And they do that because of the risk of the punitive nature of whatever the hearing is going to be. So they're exercising an overabundance of due diligence to make sure that the person who is subject to being held in contempt or punitive damages or punitive action, sanctions and the like, has a full opportunity to have their constitutional right of hearing, right, to be heard in defense, and due process rights are, make sure that they are highly regarded. That was not the case here. Dropping the documents at her feet, it even sounds like a lie. Number one, you all don't know me to be the type person to ignore a sheriff deputy in that type of regard. You don't know me to be that. I've even been known, as most recently, I believe I expressed to you all, in the case with Shamika Smith, my former client, when the sheriff's deputy left a sticky note on my door, which was completely unprofessional, but she did, done and done. When she left that on my door, I went straight to the sheriff's department the next day, volunteered myself. I presented myself. I don't hide. I presented myself and asked for the documentation that they intended to serve upon me. And then I filed upon the court an affidavit showing that I had actual notice of the record that they were intending to serve me with. So you got to some of you understand how I operate, okay? So this statement that McDaniel was served in person on September 25th by a deputy sheriff dropping the documents at her feet is absurd and ridiculous. And that is an objective statement because as it relates to my consistent character, it makes absolutely no sense. It's baseless. Okay. All right. So since 2012, McDaniel has filed or caused numerous civil actions to be filed in Guilford County, and I have. But that's not abuse of the judicial system at all. The number of cases, we've gone over this before, the number of cases that you file has absolutely no bearing on whether or not they are abusive. And considering the fact that I had succeeded in all of them, and they were all claims for which relief could be granted under North Carolina law and ripe for proceeding upon, none of this statement number 9 is irrelevant. Okay. Then we'll go on. Since 2012, it is unknown what, if any, actions may have been filed by McDaniel and other jurisdictions within the state. Go ahead. Meister did not allege or make known to the court such filings other than the mention of one action in Cabarrus County. What do you think she's talking about? The criminal case. That's why she refers to me and names me as Tigress Sidney Acute McDaniel, formerly known as Tasha Renee McDougal. Since 2012, McDaniel has 2 matters on record involving Meister. That's it. Then and I appreciate her doing this, number 12. Since 2012, McDaniel has prevailed in at least 3 of the 11 actions, one of which is pending at the time of this hearing, for which this court takes judicial notice. And remember, during this time, because they started to dispose of my cases using, through the use of this gatekeeper order. Other claims filed or initiated by McDaniel have been dismissed at various stages due to failure of Ms. McDaniel to appear in court or to prosecute her claims, although she is a college graduate with 1 year of law school and currently working on an advanced degree. And I appreciate this statement as well, because do you realize that this statement, she's letting it be known, something doesn't really seem right about this. So although Ms. McDaniel is not inept, at various stages, her cases are being disposed of because she failed to appear or to prosecute her claims, right? The evidence also shows that McDaniel prevailed in one case while she was incarcerated. This was, of course, the lawsuit against Michelle Feinstein by Bailey, my bail bondsman at the time, for destruction of my vehicle. More specifically, McDaniel avers, which means attests or affirms, that the various claims, including personal injury, maltreatment, fraud, and property damage, right? I've already told you about this, right? The evidence showed that she prevailed against one party. I did. Charles Miller, for fraud due to allegations that she had been served when in fact she had not been not. Right? She had not been. And this is Charles Miller. As I said, this is the same Charles Miller. This is him. That was the owner or is the owner of 316 South Elm Street. Okay? The evidence showed that McDaniel, because of the gatekeeper order, had been unable to come to the courthouse, to the office of the clerk of court, nor to the judge's offices, which created extraordinary vexation for McDaniel. The evidence showed that McDaniel received a letter of explanation of the limitation of access to the courts. They weren't even letting me in. Upon McDaniel, and no gatekeeper allows for restricting a party from even coming into the courthouse. Limitation of access to the courts imposed upon McDaniel by the gatekeeper order entered by Judge Webb. The gatekeeper order limited McDaniel from initiating, filing, or submitting in either the small claims district or emphasis added Superior Court divisions of any county located within the 5th and 6th Superior Court judicial divisions of any emphasis added. And she's pointing out the reason why she's saying this is because it's not lawful. And you'll understand when we get to it. Further complaint, motion, pleading, or other document, unless such filing in combined language provides, contains a certification by an attorney licensed under the laws of the state of North Carolina to practice law in North Carolina that in the opinion of the attorney, the document complies with Rule 11 and is first allowed by the chief judge of that division, whichever respective small claims, district, or superior, within the judicial district in which McDaniel seeks to file the document or initiate a proceeding. Do you understand that having that in any county located in the 5th and 6th Superior Court judicial divisions is completely against what I just read to you about the bench book standards? It was not narrowly tailored. The preliminary gatekeeper order also provided that McDaniel shall be limited from initiating or causing to be initiated any criminal charge in any prosecutorial district located in these same jurisdictions, except first reviewed and allowed by the district attorney. The restrictions of the preliminary gatekeeper order, according to its provisions, were to be as to all filings, not just initial filings. This court, in looking at the terms of the order and upon consideration of the request of both parties as to the future applicability of a gatekeeper order against McDaniel, referred to the UNC School of Government, North Carolina Superior Court Judges Bench Book on gatekeeper orders. Basics and case law examples are included in the bench book. This court reads to the parties in open court what was written related to the basics. And I've already read those to you. She recites them. Okay, and verbatim. Meister concludes in broad terms, without supporting evidence, that simply due to the filing of complaints, McDaniel's purpose was harassment, irrespective of the specific nature of the causes of actions filed by McDaniel against other parties. Are you hearing me? The evidence showed that as to Meister, McDaniel caused to be filed through a criminal court magistrate a warrant for assault. Okay. The evidence showed that the parties encountered one another outside of the small claims courtroom in the Guilford County courthouse following a hearing where McDaniel lost a claim to Meister's client, Rocco Scarfone. I'm not making any of this stuff. I'm not making it up. Owner of a restaurant incorrectly named by McDaniel in the small claims action resulting in dismissal. And a lot of you in the legal arena are aware of the fact that your case can be dismissed if there is the incorrect name of the party, right, that you're suing, quote unquote. And in my case, I can't remember specifically what the issue was, but I understand that just as Patricia Hennett noted, I definitely had more knowledge than your average person, so I could not be considered a lay person at the time. And so I know that I didn't just sue in the name of Ham's Restaurant, and very likely found the name of their owner through a DBA or a Register of Deeds records, and then went through the Secretary of State, determined, verified who their registered agent was, and then served them the complaint. But oftentimes, companies will, especially when they have DBAs, they will have various corporations that own it, and it can be a whole mess. So the evidence showed that Meister finds McDaniel to be particularly bothersome and has taken action against McDaniel due to a civil restraining order and criminal action filed in Guilford County courts due to the impugnment of Meister's integrity as an attorney. Then she says, the evidence showed that McDaniel finds Meister to be particularly burdensome, oppressive, and unnecessarily aggressive in response to her actions by the filing of the gatekeeper order due to the consequential lack of access to the courts. McDaniel has been unable to meet the terms of a certification by an attorney as prerequisite for all filings. Ms. McDaniel contends, among other things, that the preliminary gatekeeper order violates her right to access the courts, which is a fundamental constitutional right, inviolate, which means it cannot be violated, and other fundamental rights that she asserts are infringed by it, particularly as to unrelated cases, because it should be narrowly tailored to the party, right? In this case, it could have been entered properly, even though the gatekeeper order was wholly unsubstantiated, wholly fraudulent. It could have been entered properly if it was narrowly tailored to Meister, narrowly tailored to the cases that were pending against Meister, and narrowly tailored to Guilford County and the jurisdiction, which was district court. Then it could have been proper. And if they had provided clear instructions to how I could file my valid pleadings to continue to litigate my actions, and I'm talking about specifically as it relates to her, because I would still have the privy to file appeal. You can't enter a gatekeeper order so that you can dispose of someone's appeal. That defeats the whole purpose of an appeal. The court sub judice had the opportunity to observe the conduct and tone of counsel and the parties with all austerity, diatribe, aggressions, assertiveness. So she's talking about how it was very clear that we did not get along. And courtroom antagonism, such a surprise to the court that the words of caution to both sides and restraint were compelled by the circumstances from the court. The gatekeeper order suggests that McDaniel has filed numerous actions, including actions against Meister, which were frivolous. The gatekeeper order suggests harassing, vexatious, or duplicative lawsuits, that McDaniel lacked good faith or simply intended to harass, that McDaniel was burdensome on the courts and other parties resulting from her filings, and the court lacked adequate alternative sanctions. We know that's a lie, and that is an objective factual statement, because there were no other cases to refer to and to cite as a basis and substantiation for moving straight to a gatekeeper order. It was like, go straight to get, what is like the Monopoly game, go straight to jail, don't collect $200. That's not what the bench book says. The evidence showed that as to Meister, McDaniel's claims were dismissed. We already know. We know that they were dismissed through the criminal magistrate, Susan Birch. One of the cases handed up to the court, which held in an action for malicious prosecution, where a committing magistrate has bound over a party or a grand jury has returned a true bill against him, such action prima facie makes out a case of probable cause, and the jury should be directed to consider the evidence as directed by this principle. Wait, hold on, what is... I'm not sure. I have to go back to that. Okay. That's a case Stanford and Grocery. That's not me. She just makes reference to them. I'm not really sure. I have to kind of review it a little closer. But gatekeeper orders are to be used as a last resort after taking into consideration the totality of the circumstances. The establishment of justice is expressly a reason why the United States Constitution exists. The court of our land exists to achieve that goal. One need look no further than the words inscribed over the doors to the United States Supreme Court: equal justice under law on the front, and justice, guardian of liberty, on the back. Our state's constitution expressly declares that all courts shall be open, Every person for an injury done him in his lands, goods, persons, or reputation shall have remedy by due course of law, and right and justice shall be administered without favor, denial, or delay. Then she points out, justice is hardly attainable unless one has access to the courts. It's right there. That's it. Her conclusions of law. It is reasonable and proper to restrict McDaniel's ability to file pleadings, motions, and other applications for relief in the 18th Judicial District by requiring pre-approval of the senior resident Superior Court judge. The process shall be defined for the case and understanding of the parties. Like other rights, the right of access to the courts is not absolute, such that the restrictions shall be narrowly tailored to fit the specific circumstances at issue. Orders such as gatekeeper orders may be extended, modified, or vacated by another judge when such order is interlocutory, discretionary, and circumstances have substantially changed. Gatekeeper orders are to be used sparingly and not to deny access to the courts, nor as retaliation against a party who might otherwise be unassailable, unattractive, or unpopular. It is to be used only when exigent circumstances justify it and against a pro se litigant with particular caution. The gatekeeper order shall not be used to abridge or circumvent or avoid the pursuit of truth and justice. The circumstances meet the standards set forth above in that McDaniel has been unable to find an attorney willing to provide the pre-filing certification required by the order, effectively blocking McDaniel's access, an indisputably substantial condition. Meister's opposition to modification of the order upon making it permanent has been considered but found lacking. So based upon her findings of fact and conclusion of law, she ordered Ms. McDaniel shall be limited from initiating filings or submitting in the small claims division of the district court unless such claim is first allowed by the chief magistrate of Guilford County. Then she goes on in the next two and she says the same for district court, the same for superior. But what do you think she's going to say? And she also says it for, criminal charges with the district attorney. But what does she say? The restrictions contained herein shall apply to Meister and any member of her law firm in any and all matters not pending at the time of the entry of this order. McDaniel shall not be penalized nor retaliated against by Meister or any party in any other matter pending which involves McDaniel by the filing of this order, including delay in filing responsive pleadings, subject to a limit of 30 days unless otherwise extended by the presiding judge in said cases, and applicable rules of court for filings she may want or need to file thereafter. Violation of this order by McDaniel or anyone on her behalf shall be punishable by criminal or civil contempt. This modified gatekeeper order becomes permanent upon filing and shall remain in effect until such time as modification is requested by either party after 6 months from the date of this order if this matter is still pending. Understand that they then, not even, so this was June 6, 2014. When I tell you that they calculated that to the date, the Judge Carl Fox order then came 6 months later when nothing else was pending. There were no actions pending between us. Because again, they had unjustly disposed of so many of my pleadings and my filings and cases, if you will. And in December of 2014, Judge Carl Fox and Emily Meister effectuated a fraudulent permanent gatekeeper order, completely going against everything that Judge Patricia Falk has stated. And at least I could appreciate the fact that she was being objective. She neither sided with me, she neither favored me nor favored Emily Meister. And she stuck to the rules. I could at least appreciate the objectivity, even though the gatekeeper order was still improper. Judge Carl Fox and Emily Meister then entered a sweeping gatekeeper order against me 6 months later, under the guise that they were doing the right thing, but were completely violating everything that had been stated herein. Neither party shall engage in public release of information pertinent to this case, including posting updates or comments regarding the other party or the proceeding on social media, such as Facebook and Twitter. Neither party shall have any contact with the other party except for dispute settlement. The preliminary gatekeeper order shall be vacated as to all matters not related to Ms. Meister. So I was the victim of white woman tears. But it gets worse. So I'm thinking that, okay, here's what it is. At this point, I've tried everything. I can't even get past, when your appeal is dismissed, the appellate court, honey, the time standards when you're under appellate review are very strict generally. And at this point, the court's disdain has been fueled against me so greatly, there was not much I could do. And around this time, I moved to Charlotte in 2015, and I was still in my PhD program. I had achieved my PhD candidacy, and so I was just hopeful that I had no other intentions. It was already clear. I had no other intentions. I just wanted her to leave me alone. That's it. Quite simple. So I didn't file anything else against her. Not because of Judge Patricia Falk's order. Not because I was scared of Emily Meister. Not because I was scared of Judge Carl Fox. Because I wanted this to go away. It had already been so much burden and emotional distress. I wanted it to go away. And I told myself I would proceed upon the appeal for Judge Carl Fox's effectual reinstatement of this sweeping gatekeeper order, which he entered. And again, this was done on December 4th. Now this is what's important, and this is what we'll close out with. And you'll see how it's been copycatted, and now all of this should make sense to you. And I'll make sure you have a copy of this as well. This is still in the same case, 13 CVS 8774. So 6 months later, there's nothing going on. I haven't filed anything against her. I don't have any need to. I keep this in mind. I don't want any contact with you. That's all I filed. I wanted you to stop contacting me and stop harassing me, and that's it. And I was content with the order through Hennett because inadvertently, Judge Hennett had granted me a TRO against Meister. You see what I mean? Because it worked both ways. You both leave each other alone. Great. Awesome. But no, they said, okay, we're going to read this last line and we're going to plot and wait. And then as soon as we can file this gatekeeper order as a sweeping gatekeeper order against her, that's exactly what they were going to do. And that's what they did. So we have to fast forward in time so that this makes sense as to why I recently discovered this and had full understanding of what was going on, or more understanding. So basically, let's fast forward to Richard Huffman. We go back. So basically, we already know. It's been noted by the court. Everybody knows that when I was incarcerated, I filed a lawsuit against Bailey and I won. That judge awarded me the maximum because I proceeded in small claims court, and that was $5,000 at the time. Some of the thresholds have been changed over the years, but it was $5,000 for small claims at the time in 2006. The court also granted me interest. And so some of you have heard this story from my previous video. I will link that video so that you can go back to it and reference it. But basically, the sheriff, so we proceeded with a writ of execution of the judgment. The sheriff located a Wells Fargo account owned by Bailey that had sufficient funds to cover my money judgment of $5,000. They placed a levy on it that same day. 2 weeks later, there was another note from the sheriff's on record that said that that Wells Fargo had sent notification that funds were not available. That it literally said insufficient funds. Please understand, you guys, I don't know if there are any licensed attorneys who are watching this or anyone who understands the effect of a levy. The levy is not a negotiable instrument. What does it mean, Tigress? What are you talking about? It's not a check. A levy is a freeze. It is a seize. And anyone that allows for funds to be transferred out of an account upon which a levy has been placed by a sheriff or any, governing agency or authority has then committed fraudulent conveyance, okay? So basically, here I am in this scenario, and she's filed these exemptions. Some of you are familiar with the process of exemption, so she's exempted a lot of her property, right? So basically, in around 2016, I had tried multiple options to execute my judgment and get my money. And the law allows for renewal of a judgment within 10 years. So that's what I did in 2016. She did not initially answer my complaint, and she was served. She actually still lives at the same place because she's been served in my injunction complaint in Raleigh right now. Okay, and she failed to answer the complaint within 30 days. Some of you know this process, and so I moved for default judgment by the clerk on the basis that she had failed to answer within the time allowed. That default was entered. Then I moved for, you have further proceedings and you move, for execution or, different things that you can do. And at that point, I then received notice that Richard Huffman was now appearing in the action on behalf of Bailey. This is when things went completely awry. Because he then, it was very, very interesting. It was very TV show, movie-ish, if you will. He swoops in, he feels the disdain of the court against me, and the judge overturns or vacates the default judgment. Then he moves for judgment on the pleadings in his favor, saying that I had missed the deadline when I had factually not. So basically, he was going on the guise of the time frame after the default judgment had been vacated. So it was effectually conspired You see, I'm going to have this default judgment overturned, and then that basically voids all of your process, and so you miss the deadline by a day, type of thing. Okay, that is not what the law says. That's not how you're supposed to conduct yourself lawfully at all. Okay. At that point, he then made a motion for a gatekeeper order against me. And his motion he backed with an affidavit. And this affidavit, he stated that Ms. McDaniel has filed 162 cases in 72 counties. And on this basis, she should be restricted with a gatekeeper order. And I was so confused. When I first saw that, I thought, what in the world is he talking about? What is this about? What is he talking about? And so in those in those proceedings, I inquired about it. I did a civil search, and I saw that my name appeared in all these counties. So I just thought that it was because of what Judge Carl Fox had done. Emily Meister and Judge Carl Fox had CC'd it to all the clerks. That's what I thought. I thought, okay, it's been CC'd to all the clerks. See that? Now, I hadn't seen this until recently, but that, to me, I said, okay, that makes sense because it's been, Judge Carl Fox makes a reference in his order that the entire state effectively needs to know that there's a gatekeeper order against Mr. McDaniel in these three, in this specific county. Okay? Being Guilford County. And let me go to it because I want to make sure I'm not misspeaking. Yeah. Defendant shall be limited from initiating any complaint in small claims in the 18th Judicial District of North Carolina. In the 18th Judicial District of North Carolina for District Court. In the 18th Judicial District for Superior Court. In the 18th Judicial District for criminal matters. And that's what it's limited to. The Guilford County Clerk of Court shall cause a copy of this order to be sent to the Clerk of Court for each county within the state, as well as to the Chief Magistrate, Chief District Court Judge, and Senior Resident Superior Court Judge for the 18th Judicial District of North Carolina for immediate distribution to all magistrates and judges within the 18th Judicial District. So send a copy of this order to the Clerk of Court for each county within the state. But it should only be distributed to all magistrates and judges within the 18th Judicial District. So I appealed the Wake County gatekeeper order that was effectuated by Richard Huffman on this basis. And I said, it appears that what he's done is he has fraudulently misrepresented the amount of cases that I filed by including the cases throughout the entire state that show my name attached to it. So at this point, I guess I've got about, let's say that I've got 50 cases, right? And if you sent this out to 100 clerks, right, then I was, suggesting to the court, because I didn't have any other proof than this, than than his statement, because I didn't have this yet. I just recently became aware of this handwritten note on the documents, and then I did further research and was able to confirm more specifically what they did, or what she did. Or I don't know all to whom, I don't know all who assisted her. But what did I say? I said I feared that she would enlist others to do me harm. And that's what she did. So basically, I continue to fight that in that regard. And again, with there being a gatekeeper order in Wake County, they were able to very easily dispose of all of my cases because they would not accept any of my pleadings. And when I say accept, I'm talking about the fact that, you know how it was literally you're disallowed access to this courthouse, this Guilford County, you can't submit anything? That makes no sense. So that means that you are enforcing the gatekeeper order in such a way that is completely against the law. So the same thing, that's why we call it a copycat. They copycatted that same gatekeeper order, now this time padded with what Emily Meister and Judge Carl Fox had done in knowingly violating the judge's bench book by sending this gatekeeper order out to 100 clerks under the guise that it was appropriate to notify other people. You know how it says it is appropriate to notify other parties who might, where is it? I want to read it directly. Hold on. It says H, notice of the gatekeeper order also should be given to all parties who have been on the other side of cases from the abusive litigant, so they will know of relief available to them if frivolous documents get filed despite the order. But keep in mind, I've not ever been to 72 counties. I've not ever been to these counties. So notice to other parties would be appropriate if there were other parties. The parties would be limited to Guilford County and Forsyth County in this regard, because Bailey was out of Rowan, sorry, not Forsyth, but Rowan County. Bailey's bondsman practice was out of Salisbury. So I had to move, I could have chosen to move to initiate my lawsuit against her from Guilford County or where she was domiciled, where she was located, right? But there was absolutely no justification to notify 100 counties. For what? I ain't been there. I still haven't been to many of them. And I'm talking about very specifically, you all. I have, at best, connections to 4 or 5 counties. That would be Forsyth, Guilford, Cabarrus, and remember, I've not ever lived in Cabarrus. It's just where the criminal conviction was, and that should be notable to you all. I've never lived in Cabarrus. Now Mecklenburg and Rowan, and only Rowan. I've never lived in Rowan. Only Rowan because that's where Bailey's office was domiciled. You understand? So because there are 100 counties, and some of you understand this math very easily, we can very easily equate that to a percentage. So that means that 95% of the counties I have no connection to. The only connection that I have is the connection that they have orchestrated by sending it out to all these counties. And that's called fraudulent misrepresentation. So you have fraudulently misrepresented my litigative history. Because he specifically said, she's initiated 162 cases. You've heard it. You've heard the lie repeated. He didn't say Miss McDaniel's name comes up in a search, civil record search, and the gatekeeper order was noticed to 100 clerks. He doesn't say that. He says Tigress McDaniel initiated 162 cases in 72 counties. That is fraudulent misrepresentation. Okay. So now let's go back. So basically, now we have the situation where this gatekeeper order has been copycatted in Mecklenburg County. So we have the 504 violations, which I read in my introductory statement, right? And I incurred $11,000 in medical debt for my son to receive his remedial care from the allergic reaction he had from Patricia Falk giving him a food product with milk in it. It was a pretty straightforward case. I was running for office at the time. And lo and behold, F. Lane Williamson decided that he was going to move for a gatekeeper order. I was not noticed. I was not present at the hearing. And they effectuated another copycat gatekeeper order. And he referenced and incorporated the affidavit, the fraudulent affidavit by Richard Huffman. At this point, he didn't even need to refer back to Emily Meister's because the damage had already been done. The fraudulent padding to substantiate the gatekeeper order had already been done. So it was just copy paste, violate Tigress and McDaniel's constitutional rights. Copy paste, violate. Copy paste, violate. Copy paste, violate. So this keeps going on, and so at this point I have all of these appeals. They're appealing what of course the opposing counsel wants to say are interlocutory orders, and you have to understand that some interlocutory orders are unappealable, or you have to wait until you get a final order. But if it affects a substantial right to the party in the case, then it can be appealable. But of course, if you're going against a licensed attorney who is effectuating fraud, then they're going to obfuscate these things. Understand? So basically, can you just imagine the tornado of fraud that I have been subjected to? Bad faith enforcement by Judge Lisa Webb. I remember even writing, requesting an administrative order for, the review of my pleadings. Because each time I would go to the clerk's window, they would say, well, we can't accept this from you because we don't know that you can file this. You're restricted. And I would say, well, they just told me at the judge's tables on floor 9 that I can file this. Can you call and make a phone call, because I've asked them for the order and they won't provide me an administrative order. I even received a letter, which is in case record as well, from Lisa Webb saying, I refuse to give you any administrative orders. I refuse to give you anything in writing that says whether or not you can file any of the pleadings you submit. How is that proper? That's completely improper. That's a facial showing that her intent was to enforce the gatekeeper in bad faith. Denying me access to the courts. What did Judge Patricia Hennett say? Everything that Judge Patricia Hennett did was at least highly objective. So basically, at that point, I said, I don't know what else to do. I cannot figure out what is going on. Let me see if I can research this even further, because I'm not sure what exactly is going on, but something more has happened. Something more. So while in Guilford County, visiting my mom and visiting family for the funeral, I said, let me go back up to Guilford County. Let me do this search again. Let me try to look at it with, fresh eyes. That's when I found the document that said, CC this to 100 clerks. And I said, well, So that's not just giving notice to the clerks. I feel like maybe I need to go to, I had a eureka moment. Maybe I need to go to one of these counties and see what they have there. Because they actually had registered numbers. See, the way that I did the search before, however I did it, I was not familiar with the R records like that. I wasn't familiar. And I'll show you what I'm talking about. I'll get to it. And I know we're going over time, but it's a lot. I should not. I told myself I was going to try to do this in 1 hour. And hopefully you see the authenticity of this, because I'm just, and I guess that's what they expected. Not I guess. And that's not a subjective statement. It's very demonstrably clear that they intended to put me in such emotional distress and subject me to such burden that I would just be defeated, terminally defeated. But they don't know me that well. She surely doesn't know me that well. So whereas I have been defeated literally in a lot of regards, that was not the final answer, and I will have my justice. So basically, as you see, this shows you the date. Let me see this up close. So on September 22nd, let's come over. September 22nd, 2023. See that? I said, let me get the whole printout. Let me get everything that I pulled from the civil record search. And so Guilford County went ahead and printed out everything. It's 1, 2, 3, 4, 5, 6 pages or so. One even has a Lisa Ann Meister. And I thought, why would a Lisa Ann Meister? Showing the parties to the case. And we've come up with a deduction for that too, and I'll explain. So, and see, each time, there was also the issue where I was like, okay, had I done all counties versus Guilford County? Because remember, why would any other county be relevant? Why would any other county than those that I have been associated with be relevant? So this time I got the full scope. And these, I have since learned, this is an antiquated method that she was familiar with to perpetrate the registration of the gatekeeper order in every county. So what she did was an effectual backdoor circumventing the bench book standards for a gatekeeper order. So Judge Carl Fox's gatekeeper order literally said Tigress is restricted in Guilford County. And they said to themselves, how can we effectuate this in other counties even though we can't actually enter a gatekeeper order against her in all these counties because it would not comply with the bench book. So they registered it in every county. Now here's the interesting part. Evidently it was only registered in 72 counties. And evidently some of these counties are, I guess, effectively taking it off of their record somehow, because The latest attorney who's referred to this gatekeeper order, and contemptuously so, is the attorney Anthony Burks for Shamika Smith. In the case against, my former client who committed fraud upon the court and didn't follow the temporary parenting agreement. She withheld her child from going to see her father. And I was subpoenaed to court to testify in that regard. And so she decided she was going to retaliate against me and file for a TRO. Here, the sheer irony of all this, and all this stuff coming full circle. And she literally asked the judge to not allow Tigress to testify against me. That is interfering with a witness. That's a felony in North Carolina, okay? Do you see the twilight zone that I've been in? Do you understand the twilight zone that I've been in, okay? So he refers to, because he's moved for a gatekeeper order, and at this point I've moved for a gatekeeper order against him and Shamika Smith, just to be honest with you, in Wake County, so that's pending. I've also moved for sanctions against him because he's violated Rule 11 and every applicable law, okay? He even, in his pleading at one point, he says, Miss McDaniel keeps showing up at Miss Smith's hearings. I'm not showing up at Miss Smith's hearings voluntarily. I don't want to be there. I'm being subpoenaed. And if I don't comply, I can be held accountable, both punitive-wise and civilly. So, no, it ain't happening. I'm complying. Okay? We wrap this up. Now, herein lies the sheer irony as well. So, during this time, I rented a vehicle so that I could, because some of you know that my Rover's in the shop. So I rented a vehicle to go to the funeral, and I said, well, during this time I had other tasks that I needed to handle, and I said it'll be best to just go ahead and rent it for a week because I was already back and forth from Greensboro like twice. I was like, okay, it's best to just keep the car and let's see if this. Let's take this time to research this matter. Now here's the irony. They say, and even Drew in the Democratic Party, the chair, he suggested in his tone and his accusatory question that somehow, because the implication is there, to ask me the question, the implication is that someone would believe it. It is very telling of your cognition if you believe that I could file 162 cases in 72 counties. It's very telling of your cognition, specifically your lack thereof, okay? Because during this 1 week that I had the rental car, it was a complete burden, a complete whole process to go to 2 counties. I had to make sure that I could get there in a time frame based on where I was coming from, because I live in Charlotte. Remember, right? Y'all know I live in Charlotte. We know I live in Charlotte. So to get to Charlotte to Greensboro, that's about an hour and a half on a good day. Maybe on a great day, it's an hour, right? And so when looking at these, I said, let me be strategic. Let me decide which counties I should go to. I had decided upon 2. Because that's all I could do. That was it. That's all I could afford to do. And because even whereas I don't pay gas, for renting a Tesla, I still have to pay for charging. So I was like, okay, we're going to do 2 counties. Let's figure out which ones. I decided upon, let's go to the county where it has this Leanne Meister attached, because I don't know a Leanne Meister. Why would a Leanne Meister have a gatekeeper against me? Why would she have that registered? And then I thought, clearly, I think we can all deduce, and I think this is objective deduction, that if that is Meister's family member, sister, cousin, someone, right? that maybe she lived in Buncombe County, which I didn't even realize Buncombe County was Asheville until I traveled there. And that maybe she asked her, hey, you live there, can you do this, out of your convenience, can you take care of this, right? Because what I'm understanding, this CC to the clerks, understand, is different. So the CC to the clerks is something that could have been effectuated by an email. The registration, as I'm understanding, looks like something that would have to be undertaken by someone physically taking it in and registering it, based on the documents that I found. Okay? All right. Now, there may be things that I don't know, but still, the registration in and of itself was a complete violation of the bench book and a complete violation of my rights, because it has the effectual nature of entering a gatekeeper order, keep in mind, based on wholly falsified information, to subject me to punitive implications in each of those counties without a hearing. Okay? All right. So basically, and I can commit to ending at 9:30 because I'm ready to eat too, and I'll be honest with you. All right, so said I'll go ahead to Buncombe, because that's, Lee and Meister want to see what that one says, because I don't know, I'm not familiar with someone registering a gatekeeper order. Are you? I'm not. Okay, I'm not. And so I said, I need to see what else is there. I need to know, I need to see it. And then I said, something made me gravitate toward Harnett County as well. They were very kind to me in Harnett County. Shout out to Harnett County. Thank you so much for your kindness. They said they had never seen anything like this before. This is very rare. It's not something they see at all. So I decided on Harnett County, and I think that I was thinking about these counties based on what was closer. You know what I mean? Because it's Anson County, Avery County, Burke, all these places, and I'm just like, what in the world? Okay. So I get to Harnett County, and this was what I printed from Harnett County. This is the one from Harnett County. And if you'll notice, you have it date stamped 2 times. And signed by the clerk. So once done in Guilford County, you see that? And I'm sorry, this is the one from Buncombe. I'm sorry, my apologies, from Buncombe. And I'll put this in the documents as well. And see, that's my point. You see, that I've proven my point again, because my son is saying, bro, where is you? Okay? Bro, where is you? And he's 13. So back then, my son, and let him know, because I know you can hear this. I know you can. Back then, let me just show you. So for those of you who think that I just have all the time in the world on my hands, my baby said, where is you, woman? Okay, he's 13. So back then in 2013, he would have been 3. And so you all would like to believe, anyone that believes Drew's improper innuendos, Judge Lisa Bell's libelous statements in the Charlotte Observer, that I somehow abandoned my 3-year-old child and or maybe I drug him down the road with me. Not drug him with drugs, you know what I mean? I'm being colloquial now. So maybe I put him in the car, because he's 3. You don't have no choice. And I just drove around the 72 counties initiating actions 162 of them. Completely ignoring my PhD duties and my classes, the irony for which I showed up for all of them, and I had nearly straight A's. Did you see my child right now? And he's being silly in one regard, but the whole point is, like, now he can assert himself. I mean, well, if you know anything about my ASA was articulated at 3. He was definitely articulated at 3. Some of you know this. So yeah, at 3, I would have definitely been the custodian in control, but he would have definitely had some issues with me. Driving all over the state of North Carolina filing action. I'm not really sure how you all can make any of that make any sense. It's very concerning. You should be. But anyway, so here we are. So it was clocked in Guilford, then clocked in Buncombe. So I don't know if they got a physical copy of this by printing out, but I don't know. I wouldn't know all the history. I want to know what specifically transpired. I want to know. But that's what occurred. So it was registered in 72 counties, which leads me to my next question. Why didn't the other 28 counties register it? I want to know. I don't even know all 100 counties, but I want to know. I want to do the math. I want the criminal investigation to commence and someone to find out what happened in those other counties. Why didn't they register? Me and my cousin, we were pondering it, and we said, maybe those were the counties that were not willing to accept the registration. They thought it was improper, because it was. It was. It was completely, wholly improper. Especially intended in the way that it was, to subject me to punitive treatment in all of those counties. It would be completely improper for me to just go to a random county and file a complaint. And I had no history of doing so. No history whatsoever. No history in any of those counties. Remember, I'm only associated with 5 counties at best. So 95% of the counties I have absolutely no connection with. No history of filing. 0 history of filing. There are no parties there for which it would be necessary to give them notice. So even Judge Carl Fox's order saying, hey, give all 100 counties notice, was completely abusive to his judicial authority. For what purpose? So if you're looking at this and you still think that I have filed 162 cases in 72 counties, I can't help you. That's on you. That's your issue. That has absolutely nothing to do with me. At this juncture, I have filed a total of about, because remember, at the point where I explained it about 2-3 years ago, I had filed 35. And then I had explained to you the ones that were pending here in Charlotte. So altogether now at this juncture in my life, there's been a total of maybe 60. And the reason why there's been more in this period of my life between 2013 and 2023, over the course of these last 10 years, I filed more cases than I did during the period preceding 2013. It's because of my appellate endeavors and relief measures. There you have it, guys. There you have it. So I'm going to go on upstairs to my 13-year-old son, and I'm actually going to walk. I'm physically going to walk because I can't teleport, which is what the 162 cases in 72 counties implies. I'm going to walk like a human. I'm going to use a door. I'm going to physically, because I'm a tangible human. I'm not a spirit. So I'm going to open the door, and then I'm going to go up the stairs, and then I'm going to eat like humans because I consume food and I require the same nutrient intake that you all do because I am human and I cannot teleport and I'm not mortal. And I'm going to allow you to just digest all that. Okay? Y'all have a good night.